Your husband dies on a Thursday. Heart attack. No warning. You're devastated. But you remember something. He had a will. You both signed it 5 years ago. Everything goes to you. The house, the savings, the retirement accounts. You feel a small sense of relief in the chaos. At least financially, you're protected, right? Monday morning, you're sitting in a lawyer's office. He's reading through the will. Then he looks up. I need to tell you something. This will doesn't actually control most of your husband's assets. You stare at him, confused. What do you mean? It's right here, signed, notarized. He shakes his head. The will is just a suggestion, and the banks don't have to listen to it. That's when it hits you. The document you trusted, it's almost worthless. Welcome to the nightmare that destroys widows and widowers across America every single day. But what makes this trap even more devastating is that the biggest threat to your inheritance doesn't come from the courts or taxes. It comes from forgotten forms at private financial institutions that override the law with a single signature. Here's what nobody tells you. In America, there's a hierarchy of legal power, and wills are at the bottom. At the top, beneficiary designation forms. These are the little papers you fill out when you open a bank account, a retirement plan, or a brokerage account. Payable on death, POD. Transfer on death, TOD. 401k beneficiary forms. These documents have more legal power than any will ever signed. Let's say your husband opened a checking account 20 years ago. Back then, he listed his brother as the beneficiary, just in case. He forgot about it, you got married, he wrote a will leaving everything to you. Didn't matter. When he dies, the bank looks at one thing, the beneficiary form, and they transfer the entire account to his brother. Automatically, instantly. You can wave the will in the air all you want. The probate judge can't touch it. That money is gone. And this happens all the time. Ex-spouses, old girlfriends, distant relatives, all collecting fortunes because of a form filled out decades ago and never updated. The will says one thing. The contract says another. The contract wins, every time. But if losing bank accounts to an outdated form is a fatal blow, the situation becomes an all-out war when the deceased has children from a previous marriage and a second spouse. That's where families are destroyed. Welcome to the Brady Bunch trap, the deadliest inheritance scenario in America. Here's how it plays out. A man remarries. He has kids from his first marriage. He loves his new wife. He wants to take care of everyone. So he writes a will. When I die, my wife gets to live in the house for the rest of her life. After she dies, the house goes to my children. Sounds fair, right? Problem is, the house is titled in joint tenancy with right of survivorship, JTWROW. That's the default when married couples buy property together. And here's what happens. The husband dies. The house doesn't go through the will. It transfers automatically, 100% to the wife's name, by operation of law. The will is irrelevant. Now, the wife owns the house outright. Years pass. She dies. And guess who inherits? Not his kids, her kids, or her new husband. The original children are completely cut out, disinherited, not because of malice, because of a title. There's a famous case, blended family. The husband died, left the house to his wife in joint tenancy. She remarried, died years later. Her new husband inherited everything. The biological children of the first husband sued. They lost. The house was gone, and they were thrown out by a stranger. This happens thousands of times a year, and most people have no idea the trap even exists. So what does the surviving spouse do when she realizes she's about to lose everything to stepchildren or strangers? She tries to claim her legal protections, but she runs headfirst into judicial deadlines that are ruthless and unforgiving. There's something called the elective share. It's a law in most states designed to protect spouses. It says you can't completely disinherit your wife or husband, even if your will tries. The surviving spouse has the right to claim a portion of the estate, usually 30 to 50%. Sounds protective, right? Here's the catch. It's not automatic. The widow has to fight for it. She has to hire a lawyer, file a formal claim against her own husband's estate, and she has a deadline, 6 to 9 months, depending on the state. If she's paralyzed by grief, if she's sick, if she doesn't know the rule exists, the right expires. Forever. Gone. She gets nothing. There's a widow in Florida. Her husband left everything to his adult son from a previous marriage. She didn't know about the elective share, didn't hire a lawyer in time. By the time she found out, the window had closed. She was left with nothing. No house, no money, no recourse. The system assumed she knew her rights. She didn't, and the law doesn't care. But even for widows who do know about the elective share and file on time, there's another layer of cruelty. Because in America, your rights as a spouse depend entirely on geography, on which state you happen to live in. And that creates a legal lottery that can make or break you.
The United States has two completely different property systems, and most people don't know which one they live under. 9 states follow community property law: California, Texas, Arizona, Washington, Nevada, Idaho, Louisiana, Wisconsin, New Mexico. In these states, anything acquired during the marriage is automatically owned 50-50. Doesn't matter whose name is on the deed, doesn't matter who earned the money, it's split. The other 41 states, they follow common law property rules. And in those states, ownership is based on whose name is on the title. If the house is in your husband's name only, it's his. If the car is in his name, it's his. If the bank account is in his name, it's his. You have no automatic claim. Even if you were married for 30 years, even if you raised the kids and sacrificed your career, if he didn't add your name, you're vulnerable. New York is a common law state. A wife spent decades supporting her husband's business.
The business was in his name. He died, left everything to his kids. She got nothing, because legally, she never owned any of it. This geographic lottery determines whether you're protected or destroyed, and it has nothing to do with fairness. Just the random place you happen to live. And this legal insecurity is amplified by the financial and public nightmare of probate court itself. The system that freezes assets and devours inheritance while families try to survive. Probate. The word sounds technical, boring. It's not. It's a meat grinder. Here's what it really means. When someone dies with a will, that will has to be submitted to probate court. It's a public process. Anyone can see it. Creditors, estranged relatives, scammers, they all get notified, and they all get a chance to contest it. He owed me money. She promised me the house. This will was signed under duress. Challenges, delays, legal fees. And while the court fights over the estate, everything is frozen. The bank accounts, the investment portfolios, the house. You can't sell anything, can't access anything, even if you're the surviving spouse and your name is in the will. The probate process takes 1 to 3 years on average, sometimes longer. During that time, bills keep coming. Mortgage, property taxes, medical expenses, utilities, but you can't touch the estate funds to pay them because they're locked. Oh, and probate isn't free. Court fees, attorney fees, executor fees, appraisals, all of it comes out of the estate. 3 to 7% of the gross value before anyone inherits a dime. A $500,000 estate, $15,000 to $35,000 in fees just to process paperwork. It's designed to be slow, expensive, and public, and it punishes families who rely on wills. But probate doesn't compare to the chaos created by federal and state conflicts over private retirement accounts. That's where fortunes get handed to the wrong person because of a single signature on paper. There's a federal law called ERISA. It governs employer-sponsored retirement plans, 401ks, pension plans, and ERISA has one simple rule. The beneficiary form controls everything. Doesn't matter what your will says.
Doesn't matter what state law says. The form wins. There's a Supreme Court case, Kennedy v. Plan Administrator for DuPont Savings. A man divorced his first wife.
In the divorce settlement, she waived all rights to his retirement accounts, signed paperwork, legal and binding. He remarried, wrote a will, leaving everything to his new wife. But he never changed the beneficiary form on his 401k, still listed his ex-wife. He died. The plan paid out $400,000 to the ex. The widow sued, argued the divorce settlement and the will should override the old form. The Supreme Court ruled against her, 9-0. The form controls. Period. She got nothing. And here's the twist. That rule only applies to ERISA plans. IRAs? Different. IRAs are governed by state law. In some states, divorce automatically revokes an ex-spouse's beneficiary. In others, it doesn't. So whether you're protected depends on the type of account your spouse had. 401k? Federal rules. IRA? State rules. Nobody knows the difference until it's too late.
And this extreme vulnerability of people who rely on simple wills exposes the great hypocrisy of the American legal industry, an industry that sells cheap internet documents that protect no one when crisis hits. You go online, LegalZoom, Rocket Lawyer, NOLO, $99 will, fill in the blanks, print it out, done. You feel responsible, organized, prepared. Except here's the problem. A will is only valid if it meets your state's formal requirements. Witnesses, notarization, specific language. Miss one detail, the whole thing gets thrown out. There are cases where wills were rejected because the witnesses were related to the person, or because the notary stamp was smudged, or because the signature was on the wrong line. Invalidated. When that happens, the estate goes into intestacy. The state decides who gets what. Default rules. Spouse gets some, kids get some, sometimes parents, sometimes siblings. It's a formula, and it ignores what the deceased actually wanted. Meanwhile, wealthy families don't use wills. They use revocable living trusts. Trusts cost thousands of dollars to set up, but they bypass probate entirely. Assets transfer immediately, privately. No court, no delays, no public record. The rich protect themselves. The middle class buys a cheap will and gets destroyed. It's not an accident. It's by design. And in the end, between forgotten beneficiary forms and archaic probate laws, the American estate system imposes a devastating cost on couples who neglect constant document updates. Here's the truth. A will does not protect your spouse on its own. It's constantly overridden by bank contracts, property titles, and state laws. Trusting an old document or verbal promises is the perfect recipe to leave your widow or your children in financial ruin. If you don't review your beneficiary designations, if you don't understand how your property is titled, if you don't plan your estate before death, the financial and legal system will make the decisions for your family. And those decisions will not be kind. Because in America, love doesn't transfer assets. Paperwork does. And if the paperwork is wrong, your spouse loses every time.